Welcome back. So where are we headed concerning the applicable law when issues of renvoi kick in? I assume that you found some interesting information on the whole question in Lindell T. Bates' article. Let's try to sum up. The French term renvoi that is used in that context in scholarly literature refers in fact to two situations. One, to what we can call remission, which is a reference back to the law of the forum state, to the law of the trial state. And on the other hand, we have what we can call transmission, which is a reference further on to the law of another state. In what follows, we will be focusing on remission, or on Rückverweisung in German, as opposed to transmission or Weiterverweisung. In principle, as far as renvoi in the form of remission is concerned, national private international law systems can take three different approaches. They can refuse the renvoi, they can accept the renvoi, or they can disregard the renvoi. The last approach, which is to disregard the renvoi, means that the reference to the foreign law is understood as referring to substantive law only, so that the foreign state's private international law rule that refers back to the trial state is simply ignored. The second approach, which is to accept the renvoi, means that the foreign reference back is taken into account in the sense that, in the end, the substantive law of the forum state applies. The most disastrous approach is the first one, that consists of refusing the renvoi and sending the applicable law question back to the other state, so to speak. This is disastrous because it ends up producing a kind of endless ping-pong game, and it results in a perpetual deadlock. Let me explain that by pulling out my whiteboard. And we're going to have a typical cross-border dispute. On the whiteboard, a dispute involving two parties, X and Y. And those parties, of course, are based in different countries. There is a private law dispute arising between the two parties. And X is based in country A. Y is based in country B, and since we know that in a first step we have always to define jurisdiction, we have to define the court that is dealing with the case. So let's assume that the litigation is taking place in that courthouse located in country A. So country A is the forum state or the trial state. And that means that country A is the lex fori. And part of the lex fori is, of course, the private international law of country A that determines the applicable law in the first place. Now, according to that private international law, that dispute would be governed by B's law. So B's law is the applicable law according to A's private international law. But the private international law of country B states that the law of state A should apply to that case. So there is a reference back to the law of state A, and this is exactly the renvoi or the remission. So we are back to state A. But as we know, A's private international law states that the law of country B is applicable. So we are back in country B, and here the reference back that is contained in the private international law of country B provides that the law of state A is applicable. So as you can see, we are back in state A, but soon it goes on and on and on. And it's sort of a never-ending story developing here. And well, we are back in state A, and it really looks like an endless story. And we are ending up in a perpetual deadlock, which is an absolutely disastrous outcome. Well, that is the sort of problems that can arise in the context of renvoi. But how does the Swiss Code of Private International Law address the issue of renvoi? I would like to invite you to take a look at Article 14 and to reflect for a couple of minutes on what that article could mean.